Welcome back. Today, I thought it was going to be a simple hearing, a simple quick in and out. Is she going to be wearing the pink cuffs or not? But of course, nothing is ever simple in this trial, and nothing will ever take a short amount of time. Something that probably should have taken 15-ish minutes turned into an hour and 15 minutes. So, let's get into it, I guess.
Hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right. I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy of that order. On May 25, we had a hearing and an order was entered and a notice of hearing was set. That order was hand-delivered to you. Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day.
See, I knew it. I knew it was something that was so inconsequential and not intentional at all. She made such a big stink about this at the last hearing and made sure to needle it in every time she could to say, you sent my stuff to the wrong address. I could not believe she made two separate motion things talking about changing this address. Formal address correction. Oh my gosh. I remember I could not believe she wrote a whole motion about changing her address. Motion for defendant's immediate address correction. We just did this one. What? Formal address correction. She did two. She did this motion twice. Oh my gosh. I knew it wasn't a big deal in the long run, but she is the type of person who cannot let any single perceived slight go. If she thought something was intentional, she has to make sure the whole world knows and has to make sure that she can drill it into your mind that you made a mistake. I mean, ultimately, it is, what is it? What's that called? Maybe a coping mechanism or a defense mechanism. Defense mechanism, there you go. In order to deflect from her own inadequacies and her own issues, because she sees that people see that she's floundering, and so she has to show that, no, I can achieve something. She's mentioned that specific phrase multiple times in the past, that she needs to achieve something, and calling out something wrong is her achieving something. So you will see constantly, anytime she can call out something wrong, or that she thinks she called out something wrong, she will make sure to repeat it as many times as possible.
On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you had placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also a certificate of service providing you the Justice Administrative Commission's response to motions seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of Detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with address to you, your inmate number, FDC Dorm B, P.O. Box 4970, I apologize, P.O. Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th?
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st, and that was mailed to you at the same address. We've been addressing P.O. Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
And why is that? Because you want to get up here every single time and complain that everything has not been delivered at the proper millisecond, but you're not going through the documents. I remember you said on that last motion that these delays are preventing you from your, quote, real-time responses. All correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real-time response, proper notice, and preparation of all requirement contained therein. So you should know everything in that packet that you were given, because it is all so important that you need to write 2 motions or a letter in a motion in order to get the judge's immediate attention to get you those items. And then you get those items and you don't even look at them before your next hearing. All right.
Okay.
They had me sign about 4 or 5 different documents, so
Okay.
for receipt.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the P.O. Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to P.O. Box 9101.
What are you even talking about now? He brought up one thing, and you're saying 3 other documents were uploaded to a tablet, and because they were uploaded to a tablet, you know that they were mailed to the wrong address. That's not connecting for me. Things being uploaded to a tablet does not mean that it was hand-delivered to the wrong address. It could have been potentially, but that's not mutually exclusive. Maybe the one thing that was delivered incorrectly was also downloaded to the tablet, so she thinks that any document that was downloaded to the tablet at that time was sent to the wrong address. I don't know. That's so weird to me. But also, that's not even the important thing. The important thing is that it was a one-day issue. It was on the 29th, and then on the 30th, they corrected the issue. And then they handed you a packet of everything. The packet that you said you haven't even gone through. So you don't even know if that packet, it has those 3 documents that you're talking about. And you're just making that assumption. And it doesn't matter regardless because you didn't go through any of them. You're not telling me what these documents are online or the documents in the packets that you got handed to you. So you're just complaining to complain.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
I know that's right. Let her know.
Is it something that I need to record and bring back, or is it that big of a deal?
What do you mean, is it that big of a deal? You're making it a big deal. No one even brought this up again. He only tried to address this to say, you made a whole big stink about this being the wrong address. It was the wrong address for one day, and now you want to bring in all these other documents, and then when he tells you it's not correct, you're like, oh, is it a big deal? Do I have to explain myself more? Can you imagine being in an argument with her? And especially when she's drunk? She might bring up something, start an argument, and then you finally have a good comeback to it and a good argument that she hasn't said anything, and then undercuts it. Have you ever had that where someone will start an argument and then drop it when they start losing it, and then get upset that it makes it now look like you are the one who brought the argument on them? No, I don't have time for those games, and neither does this judge.
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner of Prison Break Investigations.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane a copy of our the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness lists, also proposed jury instructions, and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good.
As well.
Deputy Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses of trial. I don't have an order or...
It wouldn't be an order. It would just be that first document you read, reference, the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone?
Yes, they're broken down by folders.
And the folders, or the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
And this pertains to the digital discovery / digital exhibits that the state will be using or intends to use at trial. So if you don't know, Sarah Boone has an opportunity to see all of the state's digital evidence / exhibits and as well as their physical evidence / exhibits, and then has 14 days after that to, in writing, hand submit objections to any of those evidence exhibits being seen at trial. So it looks like they only have 9 things digitally that they want to show. And so that's going to be the video. There was 2 videos that night and a picture, so that's 3. I imagine the interrogation video would count as 1. I don't know. Does that count? I think it would. So that'd be 4. And then I guess 5 other things. Yeah, it doesn't look like there's a ton of digital evidence, especially given how big Sarah has tried to make this case seem. For them to say, hi, we have 9 things we want you to see, really shows you how open and shut this case is. Because that means they think that's all we need. They definitely have way more than 9 items they could show, and way more than 9 guilty things that they could show. So we'll see. They also could just be planning to bring in other things later based off of strategy, based off of things that they can predict or assume will come out and be allowed to come out during trial. So being like, I know she's going to trip up and say X, so I'm not going to put that in my exhibit because 1, I may or may not need it. 2, I can bring it out if she messes up and does X. And normally she can also do that in reverse, but she's Sarah.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Cacciatore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay.
What-
Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files, so I cannot open a majority of what are on both of the USB drives.
And I knew this was coming up next. I knew she was going to find a way to complain about the digital evidence because she doesn't like that she got it only in the USB. So I know she's going to complain, I can't open this, I can't read that, my computer dies this, I don't know where my USB is, the guards had broken it or something, everyone's trying to sabotage me, when it probably all has very reasonable explanations, but we will not hear the end of it. I promise you that.
What do you mean you cannot open a majority? What can you not open?
Good. Get her to name the specifics on the record because she's not going to have specifics. It's just going to be this ambiguous, abstract, everything doesn't work. The laptop isn't good enough. I don't have Wi-Fi. The service is dead or whatever. She's going to have all of these abstract things. So I'm glad that he's making her tell the literal problems. What files can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats, but there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't
What does
know.
it say?
I don't know.
Exactly. You don't know what the issue is because there isn't really an issue. Just because you can't open a file doesn't mean it's not there or that it's corrupt. I will bet money she didn't even ask anyone at the jail for help. And so she said, since I can't open it, that means they gave me corrupted files and I'm going to have to let them all know about it.
I moved on from that to try to go to other programs, so I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me, and that's what I'm trying to figure out.
That's what I'm saying. She uses these big, heavy, all or nothing terms. And then when you press her on it, like, okay, so what's the actual issue? Oh, it might have been one document. It might have been one file. But when I tell you it's all of my mail was sent to the wrong address, it's all, a majority, most of the discovery does not work. So you did one file and then you moved on. Were there any other examples? Because if you're saying that most of it, you should at least, at the barest of minimum, be able to give more than one example.
What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
When I tell you I am so in love with this man, he is everything I want to be when I grow up. I love just how he will throw it right back at her. She loves to give these big snarky remarks, but he is so smart. He takes everything super literally and responds accordingly. You're saying most, a majority. I'm not going to take that as many. I'm taking that as most, majority. So tell me what's happening. So tell me the exact number of files, because if you're saying all of these, that means you went down, down, down. It didn't work. It didn't work. It didn't work. When it really just sounds like one file had a bunch of files inside of it. And we've all seen, or many have seen, a file with a lot of files in it. Some of them have just cookie information that aren't important. Some of them have the actual movie, picture, media that you're looking for. So she's saying she didn't want to take the time to go through everything. And so she just moved on because it wasn't immediately there when she opened it.
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what
to.
for the most part means.
I haven't had time yet to explore everything due to the dorm environment.
But you had enough time to know that majority of it does not work and is corrupted. No. See, and she's already laying, this is going to be the next talking point, the dorm environment. So she sees that this file thing isn't working. So now she's about to pivot into this, my dorm setting is the reason why I can't get through any of my files. So even if the files are there, I don't know because I can't read it because of the dorm environment. Even though my first argument was saying that I couldn't read it because they were corrupted, but then you saw through that and then you made me explain myself. And so I guess that wasn't actually the issue because then I had to reveal I hadn't actually gone through most of it. Just a few files, and then I was too nervous to look at the other ones because other people were around me watching.
So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you, so you know what I'm trying to work on in order for privacy to be had.
Because there's nothing like writing a letter to the judge to ensure privacy, as she has learned so many times before.
So I haven't explored both USB drives to the fullest potential that I possibly can yet.
Okay, so then why did you say this 5 minutes ago?
So I cannot open a majority of what are on both of the USB drives.
So then what's the truth? Are the files corrupted or you haven't looked at them?
just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
Ah, and here we are. So one folder is the only thing that she couldn't get through. And in her mind, one folder equals.
I cannot open a majority of what are on both of the USB drives.
Okay, all right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted.
See, and this is why you should have asked someone at the jail for help so you wouldn't embarrass yourself in open court, well, using your terms, in front of the whole world because you didn't know how to click an icon.
So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio-only files.
Okay, all right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So, Mr. Lane, you and I would go over that when you and I meet.
I can already tell she's going to treat Mr. Lane just as her attorneys and make him be her question answerer for everything. That poor soul does not know what he is walking into.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay. All right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her, if you know?
9 a.m.
Okay, all right. I have had the opportunity to have further conversations with Major Mohammed at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No.
Meaning yes, because she likes to play that little game a lot of reverse telephone where she gets to rewrite what people were saying to her, and it's a mess every time.
One of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department so I can anticipate those discovery hard copies.
See, that doesn't make any sense. They're saying, I'm guessing they went to you and asked you, and you said, I have everything I need. And you're saying that's a miscommunication because you are telling her what you need to purge from your property bag and purge the property department. I don't know what that means. But those two conflict. She's saying you said you don't need anything, and you're saying you need to get rid of everything. I don't know. Her stories never make sense to me.
Is that Tracy Hall?
No, that was Hall. Her last name is Hall.
That's what he just said. See, that's how you know she is just naturally combative of no active listening whatsoever. Was her name Tracy Hall? No. Her last name was Hall. What?
So it was Hall, Hall, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay.
I think he was trying to save her there. I think he was trying to give her an opportunity to save face. Like, I just told you the name Tracy Hall. You said that you talked to someone last name Hall. Do you know the first name? If you were paying even a little attention, you could have filled in that blank. But I guess not. And then she said that she was sent to her as if that was a bad thing. That sounds like they sent her to you to check, do you need anything? And you say miscommunication, which translation probably is argument or snippiness. But, you know, I could just be too harsh, or I could be right.
All right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies.
Ding, ding, ding. Points for everyone. This is Sarah Boone's biggest win to date. You finally got your hard copies. Your nagging worked. You did it. All of those useless letters, all of those pens, all of those papers. You proved me wrong. I am the fool here. You are finally getting all of your hard copy discovery. I don't want to hear a single goddamn thing about it. And you know we are. You know she's going to still complain about it. Well, this wasn't everything. I can't trust that this is everything. But she can't say they are not giving her absolutely everything she has asked for. They created a protocol because at first you complained about privacy. Now you want the hard copies, and they said, okay, maybe we can make that work. And now you're going to still be unsatisfied having both of them. Oh, I can't wait to see how this turns back. This is kind of like the if you give a mouse a cookie, if you give a Sarah a discovery box, she's going to want the whole Discovery Channel. She's going to want the whole globe. She's going to want every classroom. She's going to want a personal guard to make sure that no one can see her discovery. She's going to want a personal guard for the guard because, you know, she doesn't trust the guards. So she needs someone to watch over them to make sure that they are watching over her properly. And even then, everyone's still out to get her. Okay, I promise I won't keep rambling. Okay, that's a lie.
So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can, yes.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously, and Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No, Your Honor.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay.
Oh, so I knew that Miss Cashman deposed 2 people. So the 2 people that she deposed were the 2 detectives. I didn't know if they were expert witnesses or something else. Okay. So she has those answers. Wow. Sarah Boone is going to be cross-examining her investigators in the interview. This is going to be so much gold. Oh, wow. Wow, I can't wait to see this. Wow, Chelsea versus Sarah, reverse. Ah! Okay, this is going to be crazy. There are going to be recesses. There's going to be cat fights. They're going to have to put the cuffs back on.
Were they a part of the 2 USB drives that we addressed on August 5? You had the smaller one, which was everything you digitized from the 2 boxes, and then you had the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has the physical copies, but I'd like to give her digital copies just in case.
Put it all on the record. You are giving her everything in every way you possibly can.
State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes.
Okay. If you want to, can he be released, ma'am?
I guess I'll see you at 9.
She says reluctantly.
Okay. Sir, if you could endeavor to do that today, I would greatly appreciate it.
Absolutely.
All right. Thank you very much, sir.
Thank you.
All right. The next matter this morning is the defendant's motion for defendant's reasonable freedom in movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024.
We are 30 minutes in. This is what this whole hearing was for. What we just went through was a recap and, crossing things off. But this is what this hearing was set for. We are just now getting to it.
Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion. We have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay.
Wow, so not even the state wants her unshackled, which it's slightly surprising to me. I didn't think they'd have an issue with it, but it makes perfect sense. She is a terrifying person. You think that you'd be safe, but we all know that this docile, flowery language is all an act, because she shows how aggressive she actually is in the way she asks things, and the way she comes back at people, and the way she is defiant and doesn't listen to people, but then flips it around on them. So she would probably try to escape and then blame it on the court for not trying to stop her.
So, ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions.
Oh, Lord. Miss Sarah Boone, Esquire, is going to cross-examine someone.
Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about that process?
I don't.
Okay. All right. Let's go ahead and call your witness. State.
State would call Gavin Lowton.
I'm excited to see what he's going to say. I didn't really expect them to have a witness for this. One, I didn't expect them to object for it. And now they have a witness to support it. So this will be interesting.
Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, Lwtan.
All right. Thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court and security.
And how long have you worked that assignment?
Over 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And Are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge of the defendant.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation.
She sure does. And if you don't know anything about that July 25th, 2018 domestic violence arrest, go ahead and click right over here. You know, let's see if it's up there. Click over here and see that body cam footage reaction video, because she surely did get arrested for domestic battery by strangulation.
She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings, or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
Honestly, I'm shocked it's only 3 times, but I do remember this. I remember that she would not show up to some hearings, despite the fact complaining earlier how many times she wanted to be included in absolutely everything. But then she would complain that they were wasting her time and that these court appearances took all day or whatever. So I'm not surprised one bit.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on.
Yes, because if you don't know, in America, if you're from a different country or what have you, I don't know how different law in countries work legally, but in America, they don't want the jury to know that you are incarcerated, so they'll give you nice fancy clothes. Well, not nice fancy clothes, but they'll give you regular clothes. You will be shackled, but they'll make sure that they can't see the shackles, so they'll probably put like a little cloth in front of it or some panels and things like this where they tape up the chain so that they don't make noise, because you don't want to prejudice the jury against them. Because you do have cases where there are murder cases and the person is out on bail, so they want to just make sure everyone is seen in the same light and that they can't say they only convicted me because they knew I was in jail.
She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions?
Oh Lord, here we go. You know what? I'm going to take a quick break because I need to mentally recenter, and then I'll get right back to this. Okay, I have some water and gummy worms. Let's get it.
For Officer Loden.
I do.
Go ahead.
First off, in your, in quotes, research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that.
Yes, you were. Are you serious? Do we need... Linda, roll the footage.
Hands behind your back.
For what?
For battery domestic?
Me?
Both of you. You two hitting each other. Doesn't go down like that. Alright?
Is this for real?
This is for real.
Why?
I already explained to you. Chest on flag.
Why am I in trouble?
Spread
though?
your feet Spread your feet apart.
Why am I in trouble though?
Because of
Why
the
am
marks
I in
he has
trouble?
all on his neck and the inconsistencies
That's
of
me
the story.
fighting back. I can't.
Okay, step back a little bit.
Why? Because I fucking fought back?
No, because everybody that goes in my car gets checked, no matter who you are.
No. I mean, like, seriously, like, I literally just started my job a week ago.
Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date.
And that's just a flat out lie. We absolutely know she has missed court dates and that she has turned them down. Why? Because she complained in her letters that she wants to be at every one of them, and then she complained in her letters again that it takes all day.
I want to be present for all dates going forward, please, regardless of the significance. All are significant to me. And also to communicate to everyone so you understand the undertaking it is for an inmate to attend court and why it is so important to me to have progress to report to make the day count. We are woken up at 3 a.m., taken to a holding cell and wait 4+ hours, then taken to the courthouse and put in another holding cell for however many hours until court time, for only a 5 to 10 minute opportunity in front of the judge to say anything, if at all. Then taken to another holding cell for however long, transported back to another holding cell, wait however long, then taken to another holding cell, then back to our dorm. Most court dates are court days, spent between 8 to 14 hours for little to no time to speak. It's important to me, us, we matter, hence my letters. What will be said for this one, I wonder?
So you wanted to be at every court hearing because you didn't know what was going on. Then you were mad that they weren't productive enough because you didn't understand how court worked, and the reason they waived your appearances at some hearings because you did not need to be there. But since you complained and you said, I want to be at every single one, they didn't waive your appearance. And when your appearance isn't waived, you need to be there. So you refusing to go as being like, well, you know what? You're not going to waste my time or whatever, just like she did when she would hang up the phone with Miss Cashman Esquire and then storm off saying that you're not going to waste my time. She probably did the same thing here when she rejected going to court those few times. And it wasn't a lot, but she's flat out lying when she says she hasn't refused it. And she knows she is. So this is going to be the trial where she is 100% going to flat out lie to us when even she herself knows we have proof that says the otherwise. All right.
In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor.
What are you talking about? In 5 years, you've never argued? You constantly argue. That's all you do. You have never not been confrontational in any court proceeding, letter, any interaction. You always have an aggressive, controlling tone about it. So you mean to tell me that you never brushed shoulders and you never argued with the guards? We know that's not true because they have jail records that prove she got jail write-ups. I don't know what those called, but she got reprimanded for her behavior multiple times for getting into arguments with them and getting into arguments with other inmates. So this whole, who is this act for? Does she think she's going to lie to this one officer and be like, oh, well, if you're telling me that, then everyone else must have been lying. Your Honor, I retract everything I said, and I think you should take the cuffs off.
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her the date.
Yes, receipts. Read her.
Okay.
Oh, he literally pulled out his reading glasses. He is about to go in.
On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
It doesn't matter. What are we doing here? Why are we putting these qualifiers now? You said, I want to be at every single hearing, regardless of how significant. They are all significant to me. Now you are trying to move your own goalposts again and saying, so do you know which one I missed? Because if I missed something that was not significant, then that means it's okay, right? Even though I complained and got everyone involved until I told everyone I wanted to be at every single one. And when the jail is finally making sure that my wishes are being granted and I spit in their face and say, no, I want to sleep some more. And now we're here.
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in court?
At the jail, yes.
Who is your contact, please? I've never missed a date.
This is a database that I got this information from.
Do you know when it was last updated?
She's just throwing out questions now because all 3 of those dates were in 2023. It would not matter when it was last updated. I promise it was updated at least one time in 2024.
I don't know.
Okay, so do you know how I have never missed a court date to the present date?
Which that also isn't true. I know she's talking about voluntarily, but she's also missed court dates that she wanted to be at, quote unquote, and then just wasn't. So she's missed it both voluntarily and involuntarily. So to just say, I've never missed a court date to date, you know that's not correct either. I don't know. It's just so hard for her to stick to a truthful answer.
I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going, do you know the name of the officers for each one? You do?
Yes.
Please.
For the September 15, 2023, it is Corrections Officer Portia Hines.
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
You refused court. That's all it has to say. It doesn't matter what you... It does not matter what you skipped. It's the fact that you did.
Attend court. It doesn't say specifically what your hearing is for.
Okay.
Second one, it'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene.
Yes.
10/16/23.
Yes.
Okay?
And the third one is January 28, 2021. And the officer is Jasmine Scribner. Scribner.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward in the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay? And January 28?
At approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
Did we catch on to a theme there? midnight, 0300 hours, 0334, whatever. So midnight, 3 a.m., 3:30 a.m. She wants to go to sleep. She absolutely refused to go to court because they woke her up ass crack early, and she said, no, I'm not going to go. She didn't want to spend all day there anyway. She regretted her choice to say, include me in everything, and she refused to go. 100% can see that happening.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information out.
Okay.
It doesn't matter when they did the report, unless you're saying that they did it retroactively as retaliation against you because they just don't like you. But then that would also imply that maybe y'all got into arguments to where they would want to retaliate against you and blah.
So I'm trying to figure out how it, I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to ask and answer.
Thank you. Thank you for finally objecting. I mean, I don't think it's asked and answered because she didn't ask anything. She's just making statements. She's not realizing what this is for. She's supposed to be asking him questions, not defending against his answers. If that makes sense. You can defend yourself after he's off the stand and when Kranek asks you if you have any other arguments that you want to make. That's when you make all these arguments against it. You are going back and forth with the witness. You're not there to change the witness's mind. You're there to get some information out of there. You could say, I don't know, you could ask, does it show when the reports were given? Yes or no? You don't know. So you don't know if this report was written after that time or before that time. No, I don't exactly. You can't really go anywhere with that questioning, but then you could just say that that report seems outdated or the time is inconsistent because all I know is that I have never refused going to court. There's no reason for me to refuse going to court. So if I can't understand when those comments were made, then I'm going to reject them as true. There's no good arguments here. You refused the court, girl. You did it.
I'm going to sustain the objection.
So the domestic violence, the original, was dropped. I was never charged with that.
Why do you keep circling back to this? It does not look good for you. You needed to briefly address this and forget it.
Object as to relevance, Your Honor.
Overruled.
It's 100% relevant. It's the basis for his argument. He's saying that because she has this rap sheet and because she's been defiant in the past, that he doesn't think she should be unshackled. So yes, talking about the DV arrest is relevant. This should have been objection asked and answered because she did already mention ask this and it was already addressed.
You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
She's just so confrontational with everything. That's not the part you needed to be picking apart out of that response. He's saying probably uncooperative because you both didn't press charges against each other. George did not further press charges, and because they couldn't determine which one of you was the primary aggressor in the situation, they dropped it for both of you. But you were up there for a felony. He was up there for a misdemeanor. You got lucky, even though you were the one who called the cops on him.
It said,
Your Honor, I'm going to object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information.
Wow. This is probably one of the first times I've heard her say George's name in years, maybe. The last time I remember seeing her ever address him is in one of her letters where she calls him the decedent, like an attached memory or something. But even then, the only reason she brings his name up is in order to exonerate herself, so it's not out of any genuine concern or genuine thought towards him. It's that he just happens to be involved in the lie that she is trying to deflect away from herself.
And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. That's not a question, it's a statement.
Sustained.
Forgive me, because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of.
You're not, one, they're not going to tell you. Two, you're not there to provide your information. You're there to ask questions. That's where we are in this process right now. This is a question of the witness on the stand, not a back and forth conversation. Two, she loves to use the word accuse. This isn't an accusation. He's just reading directly from a report record. This is fact at this point. But she did this in her interrogation too, when she's like, people are trying to pin this on me. This is what I'm being accused of. Is that what you're trying to accuse me of? Yeah, it's not really an accusation when you did it, but sure.
I don't know if I'm doing it the wrong way, apparently, so I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation.
This is going to be such a long trial. I get it. But just to rewind, the last thing Kranick said to her, that wasn't a response to this or anything, was, do you have any questions for the officer? And now we're here.
That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
It was dropped cooperatively. She's just using the words that he was using because she thinks she can just throw it back in the face. But he was saying y'all both didn't cooperate with going forward with the charges, not that you were uncooperative in general. Whew, she also doesn't understand the difference between an arrest, charge, and conviction. She was not convicted. An arrest is being detained under suspicion of committing a crime. A charge is being basically accused by the prosecution/state. So that is a formal accusation against you. You committed a crime. I'm going to prove it. And either you go to court, guilty, not guilty, that is a conviction. So she was never convicted, but she was 100% arrested and 100% charged. Also, this isn't like a clear up situation where you're just going to go back to the guards and then argue with them and say, no, I did want to go to court the day you told me that I didn't go to court. I did do this, even though they could literally fact check any day and could look, hey, you had court on this day. Was she there? There would be a whole bunch of people who would have seen her, logs, check-ins, a lot of transportation things. But just go with her word. She's basically just saying, wait until I go back there and I yell at them to tell them that you were lying. This is a very abuser playbook, especially the charges drop thing. I've been trying to avoid it, but it's giving me those vibes of, well, I didn't go to jail. She dropped the charges, didn't she? It's very that.
I do know that the charges were dropped. I'm just saying that is in your history.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The arrest is on your record.
But the charge for the domestic violence is not on my record.
No, you were never
Object is
convicted.
to ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
and the case was dropped.
Yes.
Yes, the case against you strangling your boyfriend on a flight of stairs was dropped, but not the case of you just 2 years later suffocating him to death in a suitcase. So, the back and forth, not a cute look.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department, so I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it a...
Your Honor, I'm going to object to the form of the question. This is a statement.
Exactly. She keeps making statements, but also, what do you mean by remedy? There's nothing to remedy here. Things that are on your report, you do not just get to go back and say, take that off, take off that domestic violence charge, take off all the times that I told y'all to F off.
Question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to that's not a question.
You're not being charged with anything except second-degree murder. But you're trying to give him information. He's on the witness stand. He is supposed to give you information. That's where we are in this process. You are not trying to convince him. You are not trying to give him information. You are trying to extract information so then you could use that said extracted information to somehow help you when you argue to the judge, hey, take these cuffs off me. I promise I'm not aggressive. That's why I've just been arguing over a non-existent issue for like the past 40 minutes.
So, a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
He didn't have to say that last part, but he's trying to throw her a bone. And honestly, I don't fault her for questions like this. I wish she would ask more questions like these so she would actually know what is happening and hopefully stop doing this, whatever this is at this point. I don't know what we're at anymore. Is this life now? Where are we? I'm sorry, I'm pausing so much. I don't drink coffee. I had a coffee. It's late. It's later than it should be right now. So that's where we are right now.
What do I need to provide to you in order to have that remedied in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
He said, if you can give me documentation that shows all of this is a lie, that these 3 separate officers at 3 different points of the year all coordinated with each other to write false reports about you not wanting to go to your own court hearings because they are obsessed with you, which she believes that. She does believe every single person in that jail is obsessed with her and plans their actions around her. Specifically because she thinks that they're going to get all this fame and notoriety and money and blah, 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 blah. She cannot let that DV arrest go. See, but this is, she said it can't be used against her, and normally it can't, but this is how she's going to get it in herself. I imagine they probably didn't even add this in the digital evidence that they gave her, because they're going to show her we don't plan to let this in. But if she gets up there and she tells the jury, I have never done this before, I have never been domestically abusive towards George before, then they'll be like, oh, okay, really? Here we are. She's making a great argument for taking those shackles off. I'll tell you what.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to ask the answer.
Sustained.
Okay, do I provide this information to you?
You can provide it to the state.
Okay. Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraints.
Damn, you walked right into that. Why would you ask that question? He was a witness specifically brought in to explain why you should not be let out of cuffs and unshackled. And then you're going to ask him, do you think I should? As though he was going to say the opposite. Wild work.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024.
Yeah. And 2 years later, you killed that same man. What are you talking about? And then the next 4 years after that, you've been in jail. So you haven't killed anyone else because you were put behind bars. You kept getting more and more violent after 2018. You're trying to say, oh, that was so long ago, as if you haven't been detained and not allowed to be violent against other people. Everyone in your life says that they saw every man in your life, ex-husband, George, marks all over them, scratches all over them. You have been consistently violent most of your life. But okay, 2018, 2024, I can't believe, oof.
Okay. And you're going solely off of, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
Exactly. She's acting like strangulation is just hitting someone upside the face. No, strangulation is intense. I've mentioned this in the past. It's a huge threat indicator for potential partner homicide. Because it is intentional, because there is emotion behind it, it is very hard to choke someone unintentionally with no motion behind it. First thing that comes to my mind is the Gabby Petito case of he was found to have choked her prior. They didn't take that as seriously as they should have, and then that's how she was killed later on. It is a very passionate assault to try to control someone's breath and life in that way. And it just so happens that George's death happened in a similar manner where she took away his breath. Wild to me how she doesn't think people see her as a violent person.
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
Okay. I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
After that interaction, how could anyone see her as not compliant?
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been.
correct. It's in your history.
Okay.
She can't let it go. She can't let it go. She thinks charges being dropped means no one can bring it up ever again. I felt a little bad at first covering the old body cam footage, but the behavior is the exact same. The exact same. Sober or not, she is dangerous.
Thank you for the information.
Any follow-ups, Dave?
No, Your Honor.
Fine. Thank you, sir. Anything else, Dave?
Not from the state.
Okay. I see Deputy Barnett here. Could you come up, sir?
Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Sir, good afternoon, or good morning, rather. Could you state your full name and date of birth for the record for me?
My name is Chad Barnett.
And not your date of birth. Sorry. Could you spell your name for the record?
CHADBARNETT.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
Kranik is actually being very nice here because the state did not call him up. Kranik called him up himself. And I think he's giving her another option through this stun cuff. Oh my gosh, meaning we could have gotten to this so much sooner if she had asked that guy like 2 questions and let it go. He had already lined up a contingency plan for her. But he can't tell her this because that would be giving her legal advice. So he's just calling this guy up here being like, tell me any other options that theoretically might exist if possible. Hint, hint, Sarah, maybe you should ask for this. I can't give you advice, but now that you know this is an option, wink, wink.
Stun cuff is an electronic device that's wireless. It's box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons, so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it is at a level 3.
And what is a level 3?
Level 3 would be failing to follow the directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. that is pretty much fighting, escaping, attacking another person.
Okay. All right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
All right. Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, and you can take it off as court every time you exit the courtroom. It takes a few moments besides signing the waiver and securing it to the leg.
And it's a one-time waiver?
Each day you will have to re-sign the waiver.
Okay, and so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes.
and remove?
Yes.
Thank you.
Any follow-up?
Nothing to say. Why?
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You would be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right. Thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackled motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
Yes, Sarah, very good. And I'm not even being facetious at this moment. Yes, you picked up on exactly what they wanted you to pick up on. Now, let's see if you can just take it home. Just ask for it. Just ask for it.
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
Oh my gosh, let it go. First, Kranick was towing the line there, but he towed it really well because she asked if they were giving her the option. He can't answer that because that would be giving legal advice. But then when she asked, is that an option? He said yes, because it is an option, but he is not telling you to take that option. Also, just let this go. The non-compliance is not important to this at all. The state objected to you being released with no cuffs. They had a witness. He said, from the sheriff's whatever, he said he agrees. He does not want you unshackled. His support for not wanting you unshackled was your prior DV arrest and your non-compliance at the jail. That was just his support for the state's support, not legally binding or anything like that. These are just arguments that you are making to Kranick in order for him to rule on whether to release you or not. She will not let this go.
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Then maybe you should have put that in your motion instead of saying, I want to be unshackled, uncuffed, moving freely, comfortably, equally, efficiently, advantageously, all these other adjectives. You wanted the world. Now you just want the cuffs off. Be specific. She wants everyone to interpret what she's saying and filter it into the best light possible so that you give her the best outcome for whatever she just throws at the wall. No.
Okay. Ma'am, thank you for that clarification. Because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move, as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right, I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
There's so much here. I feel like I just short-circuited. She's basically, I mean, she does this constantly, but she's blaming him for her not being able to communicate properly or effectively. She is saying, anytime I say to you and give you all these demands and these 53-page letters, that is for you to ask me questions. No. When you make those demands, those letters, that is you providing that information. Your explanation needs to be in the whole thing. This isn't just let me assault you with words and then you need to come crawling back to me asking what I meant so then I can clarify it for you. And I could have just clarified it for you the first time and not asked it like I was a 5-year-old going on a tantrum after learning what a thesaurus is. And she's putting the onus on the judge to make sure he understands her rather than she making sure that she is understood. That is crazy work. That's honestly, that's some nasty work right there. To say I can do whatever I want and it is still your fault for not asking me why I did whatever I want, and now you're punishing me with no counsel just because I abused every single resource I had before. Why aren't you giving me more?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand by you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom.
Unshackled, unhandcuffed to function equally and comfortably while utilizing the courtroom. Whew. Now that's a title.
All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed. The defendant is simply requesting equal, comfortable, functional movement.
You can tell with her facial expressions, she hates having her own words thrown back in her face. Because once she hears it out loud, she knows how it sounds. That's why she doesn't talk this exact same way that she writes. Because when she gets behind her, not keyboard, behind her big ballpoint pen, she grows all this strength and she feels like she can say anything about everyone. And then having that defiant language set out in open court in front of everyone, you could tell it doesn't sit right with her.
To achieve advancement in her forfeited right to counsel by the court.
Okay, but damn, these camera angles are shady. Not you zooming in on the pink cuffs.
Which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to
No, not even closer.
function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
I love it. He's taking all of her flowery language and exaggerated writings as literally as possible, so that now she needs to be concise with what she's asking, because if she keeps it up, she's going to imply something that's not what she's asking, and it's going to get denied. Or he's going to take it literally and grant it, and she'd be like, well, no, that's not what I meant. I just meant this general thing, but I just wrote it super snarky and mean for no reason, and now you thought that I actually meant those words when I just wanted a rise out of you and I wanted you to give me what I want.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs mean unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not, so that again, that was why I was trying to be transparent and up forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please,
Okay.
yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial.
Limited, reasonable movement would have been perfect to put in your motion. But no, you said you wanted free, equal, free, and comfortable movement because you want to make sure that you are equal with everyone. You're not. You are an inmate. You lost a lot of rights when that happened. You are not going to be equal. You are not going to be walking around just how they would normally. We saw this with the Darrell Brooks trial, where the state and Darrell Brooks both had to stand or like sit behind their desks primarily, and the state wasn't allowed to have their exhibits too far away from them. That way, visually, it didn't look like they were too far off, and it looked like both parties were following the same rules. And that way, it kind of makes it seem like, oh, she's not in prison right now, or not in jail right now.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you are seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial. Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, so now we just backtrack to retrack again. Oh, this is so annoying. And I can see another behavioral pattern here where she steps back from, she makes a claim, then she steps back from it to try to save face, and once everyone's agreed that she stepped back from it, she'll agree with the step back by then reasserting the original claim. In this instance, because I know that was confusing, it's I want everything unshackled because I want free, equal movement just like everyone else. And the judge is like, well, based off of what you're asking me, I have to make a decision off of the complete freedom you're asking for and the support that we have been given by the state and the other deputies says you should not be free like that. However, you now are clarifying you just want the cuffs off and that you're open and willing to different types of shackling, what have you. Then I can rule on that motion to make that kind of decision. So that's why he gave her so many chances to clarify. And then at the very end, she comes right back. I want to be able to move equally with everyone else. You can't. You aren't not equal. I get it. You really want to be. You want that equal comfort and movement. Do you know who else wanted that equal comfort and movement? I'm afraid you wouldn't get the answer right because you forgot about him this entire trial anyway.
Okay, thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at the counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed.
For fuck's sake, can you ask for anything nicely? She doesn't get, everyone is trying to help her. They are trying to give her what she wants. She wants to be unshackled. They're giving her all of these options. Obviously, they're going to grant it in some level. They're going to release her on some level. Instead of actually leaning into that and saying, oh, these arguments I like all of these, middle ground things that you've offered or that we've just found out and I want to go with that method. It's unfair that you're forcing me to do this, even though he's about to hand you exactly what you want.
To be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled? Or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panel is located in front of defense counsel's table, would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally, just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
And that's all you had to say. You didn't have to be rude about it with the other parts. All you had to say is, I like this other option that just happened to fall in front of my lap that I've never heard of before today. I would like the handcuffs off. Can I sign whatever and get that? We would have been out of here 30 minutes.
Got it. Any closing remarks, Mr. J?
No, Aaron, just address all the concerns which is part of the court's plan.
Got it. All right. Thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, and especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to noncompliance in jail for purportedly refusing to return to show up in court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first.
If I were Mr. J, I'd be like, ew, she can't stay over there. She gotta get right next to, okay.
state any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so ma'am, the court's gonna grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free, and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you, and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right. The other item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained.
Back to the shady camera angles. See, I get why she doesn't want cameras in the courtroom for her evidence. Y'all would zoom in right on the suitcase.
Her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedure, Deputy Loden? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes,
Also,
sir.
Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off
In
when
advance.
she gets up here.
Yeah, I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. And as identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It
be
is
just...
under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Yes, document even more special treatment for the record. He had this lady called in to consultate with you specifically to find clothing that you won't object to. I mean, you will. You'll say nothing is good enough, even though it'll be the first time you've worn regular clothes in years. There'll still be something about it. I'll be interested to see Miss Esquire's fashion choices during the trial. I'll try to be, nice about it. Maybe, nope, I'm not even going to say it. I was about to talk about appearance. We're not going to talk about her appearance, okay? See? Train agrees. Good Train.
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go, and I'm going to give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was gonna, either you could do it or I was gonna have the deputies do it. So, ma'am, I envision that because you're gonna be able to move about freely and our jurors are not gonna know that you have any restraints on you and they're not gonna be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand, and you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself, or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal be seated closer to you, so that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please.
Yeah, I bet it is, because it's just more special treatment. But this looks so good on the record. It is all this fight back and forth, and she's still getting what she wants. And honestly, the more special treatment she accepts, demands, and gets, the less strong it all looks on appeal. Because it's, the court did go out of his way to try to make everything he could work for you, given the circumstances.
Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State anything to clarify?
No, Your Honor.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today.
Okay.
Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
No, God! No, God, please, no! 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 No!
Yes, please.
Yes, ma'am.
In regards to the status report you were just speaking about regarding them providing me with a laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate P.O. box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, well, my concern was they're not stating what it was that I looked at for how long and...
Oh, girl, bye. Don't nobody care like that. Oh my gosh. She really thinks people think that she is that important. This case is not that complicated. You are not that important. Again, the case is bizarre. You are bizarre. That is why we pay attention. No one cares what you're looking at and for how long. It is like a library. You checked the laptop in, you checked it out. That's it.
I don't know that they're going to record that information under the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, We didn't discuss the physical evidence, and I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state.
Yes, he keeps those receipts strapped on him. Straight to paragraph 5 as soon as she tried to say we didn't go over X. Yes, you did. You know you did. You talked about physical evidence for so long in that last hearing, but you just want to say, oh, we never went over it, because your actual question is, did you decide whether the media can stay in or not? And he's going to tell you the exact same thing of, I'm still looking into it, because she's not understanding the news has their own constitutional rights, and your wants and needs don't just usurp everyone else's constitutional rights.
Physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. at Courtroom 12A, Orange County Courthouse, and then the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question, though, was, are you still trying to decide or research having the media here in the
yes,
courtroom?
ma'am.
That wasn't your question, though. Your question was, we didn't go over any of the physical evidence and media, so I don't know. Because you started your quote-unquote question with an accusation. So, as always.
The case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space, and Mr. Lane's taking care of that today.
So as of today, August 9th, 2024, she finally has both digital and hard copy of her discovery. She has everything she's ever asked for. I don't want to hear about it ever again anymore.
I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing. We can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th?
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problem. It's the Miami Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that'll be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state?
evidence. The digital evidence only.
Of the 2 USB drives from Mr. Lane?
No, ma'am. The USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This is the letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer.
Are we serious? I knew she was going to complain about the digital evidence because she has to complain about everything. It is a biological need she has inside to be dissatisfied. It just is. She cannot function with satisfaction. She can't. So there has to be something wrong. She is now saying the fact that they pull the jump drives out with the logs that say whether it was checked in or checked out, and the biggest offense of all is she went in, grabbed it with her own hand, and handed it to me. I don't know where it has been. Don't nobody care about your goddamn evidence. Don't nobody care. The case is open and shut. Nothing in there is going to save you or whatever. They would be breaking so many of their own laws to be sitting there going through your own evidence trying to, how can we get one over on Sarah today? Just my God. And then you want to keep it in your drawer next to you? And then you'll still blame them because y'all get searched all the time regularly. So when they go in and they search your wherever, and if something's missing, you will blame it on anyone else in that open bay dorm. Nothing you say makes sense.
Along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives, and just as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I...
No, again, sorry. I can't even apologize anymore. This is me ranting to the ether, okay? This is for me now. I'm sorry. This is you backtracking to retrack again. We went at the beginning. Almost all my discovery is unviewable, it's corruptible, it doesn't work with the USB. How many files? One folder, then I moved on. Well, wait, I couldn't even get through half of it. I didn't even know the rest of it because I don't have time. Now I'm going to bring it back up. Like I said, many of the files didn't work. You're saying files when you really can only name one folder, and one folder with many, many files in it or whatever, or subparts to it. But my God, is this infuriating.
I visit with him.
Ma'am, you can give your letter to the deputy. We will file that in the court file.
Also, that letter is not to the judge. It's to us, right? She says that letter is to whoever captain she's talking to. The judge has no control over that. Like he said, he was provided the protocol by the jail. That does not mean he controls the protocol, and you know that. But you know that handing this letter means it gets uploaded online, and then you can use that to go to the captain saying, I know my letter was delivered to you, so you can't ignore me. You have to come talk to me. And it's also to let us know, look how disadvantaged I am. But what else is it doing? It's publicizing your case even more. So when you come back with that argument during appeals, every single one of these letters that you keep giving to the court, knowing by law it has to be uploaded, will stack all the way against you in your publicized comments, because you just made the comments here. You let him know. You don't need to give him the letter. You just told him everything that's in it. And he still can't do anything either way.
Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain DiGiovanni was returning on August the 12th from vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on the media request, or prevent media from being at the September 3rd discovery viewing hearing, will address your concerns as identified in this letter, and have a representative from the jail, be it Captain DiGiovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
We know it is literally the only thing that you have talked about ever since he said the hearing would be in the courtroom. The only thing that you've talked about. We know your position on it. I still don't care. Honestly, at this point, I hope they do keep the media in. I've completely flipped. I've been fine with the privacy. I get why she wants it, and I get why he's going to do it. He probably is going to get the media kept out of this one, and that's great. But right now, because of just the way she is, and because of it's so late right now, and I have died inside, I want the media to stay in. Let's do it. Keep the cameras rolling. Bring back the shady editors. Zoom in tight on that baseball bat. I want to see the blood stain on it. Okay, that was a little too far.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded inspecting and testing and photographing, I believe that is my business only. And
your business and the state's business and the court's business and all the deputies and their businesses. You're not viewing this by yourself, and Mr. Lane's business. So I get it, but also get over it.
One bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence viewing, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of the mail. It was already mailed? Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
All right, and that is that. That is the August 9th, 2024 motions hearing. And in summary, Sarah Boone got absolutely everything she wanted, and she complained about it for 2 hours. Every step of the way, she fought back. They bent over backwards to give her everything. We reached back out to the jail. The jail said, psych, we can actually take it. Cool, here you go. You're getting it today. Still argued about it. You're getting the shackles taken off. They basically were trying to walk you to the direction they wanted you to go to, You fought back again and again and again, arguing with witnesses on the stand, back and forth. It's not a conversation, but you know everything, right? Because you wanted to tell your lawyers how to do everything. And now, look at you. At least you understand that you are, quote, uneducated in this manner. That does take some self-awareness, and I'm proud of you for that. However, this should have happened way before this, and you would have avoided all of this. And now you're going to be mad because every second you're going to think, oh, everyone's saying that I'm doing everything wrong, and everyone's judging me this, and everyone's judging me. Yeah, we are. We are. Why? Because you brought yourself here. You didn't have to, but you did. I'm sorry, this has been the most rambly one, I'm sure. Yeah, I've been at this one all night, had to take some breaks, came back. I'm a little in that, that little loopy state, that kind of sleep drunky state of I'm fine, but am I? Which is how I feel after any one of these Sarah Boone's videos. I'm fine, but am I? Will you all let me know? Am I okay? Am I okay? Am I gonna make this through? Thank you all for the support still. Comment, like, subscribe, dislike if you're feeling it. Until next time.